Thank you, Konstantina, for this kind of introduction. And of course, thank you to Andreas Sarmoser and Professor Freemuth and to the teams at the University of Vienna and the Ludwig Boltzmann Institute for organizing the conference, and of course, for having me. I think, as for many others here, this is my first in-person conference since February 2020. So when I say that it's a pleasure to be here, that really takes on a new meaning. So as Konstantina mentioned, although our panel's title indicates that we'll be discussing open source evidence in international criminal proceedings before domestic courts, I'm afraid I'm neither going to be presenting exclusively on open source evidence nor on domestic proceedings. Rather, what I want to do in my 20 minutes is to focus on the broader use of technology, including but not limited to open sources in the investigation of mass atrocities. And in my intervention in particular, I would like to do three things. First, provide a big picture overview of what I see as the potential presented by open source investigations alongside other documentary technologies, and how I think they're already reshaping the field of international justice, which, as I will submit at the end of my presentation, I believe is itself in considerable evolvement. Secondly, I would like to talk about the main challenges that I think, or some of the main challenges that I think are presented by open source information investigations. And finally, I'd like to offer some thoughts on some of the open questions arising at this juncture, and also some of the research projects that we are carrying out at the University of Oxford to try and address some of these questions. And I hope that these three objectives will set the stage for Jeff's and Yvonne's presentations, and I'm looking forward to very much. Well, this isn't working. So I should clarify that the thoughts that I'm offering today are actually coming from an article I recently co-authored with one of our fellows, Kirsty Sutherland, who's also a defense counsel at the International Criminal Court. And the article was published in the Journal of International Criminal Justice Special Symposium on New Technologies and Investigations that my co-panelist, Professor McDermott, co-edited. And I recommend to everyone who hasn't seen the special issue to check it out. It's a must read. Now, based on our research for new technologies, or I guess technology-derived forms of information, are chief candidates to propel the international justice field in its new frontiers: geospatial intelligence and remote sensing capacities, or what I will refer to as GeoInt, online open source information, or OSINT, financial intelligence, or FinInt, and a range of documentation technologies, which really range from simple photo cameras to specialized softwares like one of my all-time favorites, the Eyewitness to Atrocity app. An important caveat to make is that I'm not absolutely arguing that these technologies or forms of information are entirely substitutive or more traditional forms of evidence and approaches to investigations, but rather I think we're starting to see more and more the many ways in which they can act as a force multipliers. First, one area that I think is ripe for research is how these technologies and forms of information can better feed into early warning systems and bolster preventive action. Social network analysis and GeoInt, for example, can be used to help track the movement of convoys. That, of course, includes military convoys as well as groups of fleeing civilians. As we've seen done in many places, ranging from Sudan, South Sudan, the Central African Republic, the DRC, Niger, and Myanmar. Technology can also help track the mood of specific groups. Techniques that, if improved and of course subject to proper oversight, could help make more accurate predictions about the potential onset and even location of identity-based violence outbreaks. Furthermore, I think targeted and combined financial intelligence tools can be deployed to diminish perpetrators' agency and structural opportunity to commit crimes, leading, for example, to, of course, the freezing of assets, the imposition of financial sanctions, issuing of travel bans. We see this happen a lot in counterterrorism, but I think that there is more that in our field we can do in this sense. Second, as Jeff has written, new technologies have a potential revolutionary nature to them, and that they can help democratize the justice process in contributing to bring hidden and unrepresented voices to the fore, but also, as some of our research outlines, they can contribute to overturning state narratives and allowing for greater oversight and transparency. And because digital technologies can theoretically be used anywhere, they permit for the meaningful monitoring, documentation, and investigation of possible atrocities remotely, even for so-called black hole environments. So geointelligence, for example, including satellite imagery, radio, radar, and other forms of remote sensing can be used alongside open source intelligence to corroborate human testimony and to help identify the construction of and use of military installation or other buildings, such as prison camps and mass detention sites. For example, in an effort that I was a part of alongside my co-author, the International Bar Association's War Crimes Committee leveraged satellite imagery and defectors' testimony to establish the exact location of Kwanliso camps 14, 15, 16, 18, 22, and 25 that, of course, the North Korean regimes are denied existed. And more famously, Pulitzer Prize winner Alison Killings has used satellite imagery to expose mass detention sites in the Uyghur Autonomous Region in Xinjiang. And of course, while measures can be taken to fool satellites, the prevalence, independence, and consistency of satellite imagery makes it today more difficult than ever to sustain denials of wrongdoing. Furthermore, these technologies have the potential to help overcome or at least mitigate biases identified in traditional investigative methods. For example, selection biases in witness interviews or confirmation biases in investigative decisions. In fact, we're already seeing that these technologies are, and particularly geointelligence and open source intelligence, find their way into a range of legal processes, both domestically and internationally. For example, with regards to the attribution of international wrongful acts and state responsibility, some of the examples that come to mind are the work of Bellingcat and other open source investigative journalists in Eastern Ukraine, which have fed into the Dutch-led joint investigations team's probing of the downing of the MH17, on the basis of which the Dutch government has challenged Russia before the European Courts of Human Rights. The Gambia's, of course, reliance on satellite imagery analyzed by the UN fact-finding mission in Myanmar in the proceedings that they initiated on the applications of the of the Genocide Convention before the International Court of Justice. And of course, one might think of the many documentation efforts of Syrian civil society, which have fed into the OPCW investigations of the Douma chemical attacks, and based on declassified French intelligence, have helped attribute the attacks to the Syrian regime with what they say is a high degree of confidence. And of course, well, I guess a slightly different example would be the Caesar files. And I think it would be interesting to see whether and to what extent they will be used in the proceedings that the Dutch and Canadian governments have announced they intend to initiate at the ICJ against Syria for violations of the Torture Convention. And of course, we're also seeing some of these information and technologies feeding into a range of proceedings concerned with criminal or civil liability. For example, it's worth mentioning the domestic civil lawsuits in the US against the former Sri Lankan Secretary of Defense, convictions obtained in the Democratic Republic of the Congo with the support of evidence that was gathered through the Eyewitness to Atrocity app, criminal proceedings initiated in the Netherlands against Ukrainian and Russian commanders of the Donetsk People Republic, and of course, the various cases that have been initiated in various European jurisdictions against Syrian officials and the International Criminal Court, the Al-Rafali and Al-Mahdi cases. So if that's a promise, and insofar, I guess, at least as investigations, the promise of these new methods and technologies seems to be boundless, there are important challenges worth taking into account. I think Yvonne will talk more in more detail about issues of admissibility, so I'm not going to get into that. But the challenges actually start much earlier and affect each phase of the life cycle of evidence differently. First, unequal access to internet services and other documentation technologies can give rise to important gaps in evidence collection. So for example, when in September 2019, the Bangladeshi government banned the use of 3G and 4G and SIM cards used by the Rohingya refugees in Cox's Bazar, citing security concerns, and they only restored internet access in August 2020, that created a gap in collection of evidence that potentially would have been crucial to the UN independent impartial mechanism for Myanmar. In addition, over-reliance on digital and open source information can foster or entrench biases in collection that, if not addressed properly, can distort the picture of violations and crimes documented. As we write in our article, over-reliance on the observable, a bias towards the visual and documentation, might neglect less visible violations such as gender-based violence, starvation, crimes against children. And of course, who collects the information also matters, because collectors' agendas and mandates, as well as sometimes donor-driven prioritization of certain types of crimes, can also be at play. Furthermore, to add an additional wrinkle to this, online misinformation and disinformation campaigns, but also hidden biases in algorithm design and input can also shape understanding and narratives about conflicts and situations. And as a consequence of that, they could influence witnesses' own perception of the events. And for this reason, it is not only crucial that investigations actively counter potential biases and blind spots by looking for information on certain types of less visible violations, but also that they diversify their sources as much as possible in an effort to compensate for blind spots, cognitive biases, and asymmetric power balances. Other crucial issues are the verification, authentication, proper secure storage of the information collected. Some tools available to the civil society, such as, again, I did say it was one of my favorites, so the Eyewitness to Atrocity app does already, they go, I guess, a long way in addressing some of the concerns on security and integrity of materials. For materials uploaded to social media sites, of course, the retention and creation of metadata is crucial to safeguarding authentication. And that's because by carefully examining metadata where available or by conducting reverse image searches, investigators might be able to detect misinformation. And this is key, given that mechanisms are scrutinizing conflicts involving major states are likely to be targeted with disinformation and false flag campaigns that are intended to distort or impede investigative efforts. And furthermore, as technologies get more and more sophisticated, detection of doctored content will become increasingly difficult to the human eye, reason why detection can benefit of artificial intelligence. But the high volume of materials required to train systems make this a feasible option only for data-rich situations like, for example, Syria, but less so for information black holes like the DPRK. Furthermore, disinformation and fabricated or otherwise falsified information can spread very fast on social media sites, making verification and authentication even more important, because disinformation risks not only polluting investigations, but can actually actively contribute to the commission of violent acts. One of the many examples here that comes to mind is the images published by international media of the Buddhist monks that were supposedly burning Rohingya victims in Myanmar. Then, of course, the authenticity of these images was debunked when it was proven that they actually showed the cremation of victims from China's 2010 earthquake. But meanwhile, the images have spread and caused very strong reactions on essentially entirely baseless claims. And incendiary images and clips, even when authentic, are problematic also for a different reason, which is social media companies might take them down because they violate community standards or company policies against violent content or incitement to violence. But at current stage, this is not yet occurring in a manner that would satisfy evidentiary standards, the abidance of which is, of course, crucial to judicial proceedings, especially those of the criminal nature. And so to provide one example of this, Facebook was initially criticized for not reacting quickly enough, or actually at all, to the spread of hateful content that fueled the violence in Myanmar. Eventually, they announced they were taking down, they took down 64,000 pieces of content in the third quarter of 2018 alone. However, not only for many, this was too little too late, but even though Facebook has reported that it's coordinating with the UN Myanmar mechanism to provide relevant information, it is of course entangled in legal wranglings in US domestic courts, and it has actually admitted to losing because it didn't preserve, but simply took down a significant chunk of the information that would have been relevant. Another wrinkle is presented by the automatization of content takedown. For example, YouTube, between July and September 2020, YouTube took down over 7 million videos because they violated its community guidelines, but 93% of which were taken down after automatic detection. But we have essentially no idea as to whether this information is being preserved, and if so, how it's being preserved. So that's potentially tragic. Now, beyond, of course, authentication and verification, weighting probative value of the information is crucial to investigations, and that for legal actors is not as simple as a binary assessment or true or false. I think maybe Jeff will speak further on this issue, but in our article, we suggest that one good option for investigators is to adopt a tiered category of probative weight approach to these materials, which some organizations like Air Wars, for example, are already adopting. So a tiered approach, the reason we recommend this approach is that it's more conscious of information asymmetries and digital divides, blind spots, and it actually, I guess it recognizes that unverifiable sources or materials might not necessarily be a problem with the information itself, but maybe with the investigation. And also this type of approach can be helpful to national authorities because it provides for a provisional assessment of probative value and accommodates for a variety of evidentiary standards. So I won't explain what the approach looks like because I think it's fairly self-explanatory, but rather perhaps in the interest of time, what I will do is I'll conclude with by saying, first of all, that our assessment on the potential and challenges of new documentary technologies, including open source information, is obviously mixed. So our team at the University of Oxford is a strong believer that these technologies constitute the future of international investigations and proceedings. At the same time, as I think my presentation has at least in part illustrated, there are many gaps and wrinkles that require us collectively to do a lot of work to be sure that these technologies can be used safely and with the proper level of oversight. Based on our interviews, there is a lot of appetite among civil society actors, as well as domestic and international authorities to move in that direction. But doing that will require concerted efforts by many in the international justice ecosystem to be sure that at a minimum, these information and technologies are not harming legal proceedings, but in a more hopeful vein, maybe even further accountability processes. And the reason I say concerted efforts by many is that this is also something that is arising from our interviews. It's not just the nature of the evidence, but is the international justice ecosystem as a whole that is evolving. We have conceptualized this evolution as comprising of an upstream flux of information. These are documentation efforts emanating from the civil society, although of course it is important to acknowledge that the civil society documenters are not a monolith, and that of course varying degrees of expertise and capacity persist. We also conceptualize a downstream flux of information and evidence, which is the one that reaches judicial authorities, hopefully eventually. Our interviews indicate, and I guess that's maybe a novelty of our contribution in this space is that actually increasingly we see UN mandates sitting at the heart of this ecosystem, in which they're fed information from the civil society, they process it in some form, and then they feed it to judicial authorities. So for this reason, one of the major research projects that we have looks precisely at the role of these mandates, but also the challenges that they face at this juncture. And although the mind immediately goes to the novel mandates, so that's the IIIM, IIM, and UNITAD. Actually, our research looks broader than that and looks at mandates that have been emanating since 2011 circa from the Human Rights Council. These are human rights entities that are essentially been consistently asked to make contributions to accountability, and we're trying to figure out exactly what that means and what that could look like. We're basing our analysis on, as I was saying, a series of interviews that we're conducting both with civil society actors, with domestic investigators, and this is to look at the, I guess, upstream and downstream pieces of the puzzle, but we're also looking kind of under the hood of some of these mechanisms by consulting with the Office of the High Commissioner itself, by consulting with the leadership of these mandates, but also with the staff. So those that are working on the cold face of are the cold face of mandates work. So we conducted actually a survey, an anonymized survey of about 103 staff that we distributed with the cooperation of OHCHR, since they have, of course, responsibility for staffing, budgeting, and budgeting mandates emanating from the Human Rights Council, but they've also played a role in the startup phase of the novel mechanisms. I guess what we find is that both civil society groups and prosecution authorities increasingly look at these mandates for a range of functions that go beyond being mere repository of information, from coordination of and guidance to civil society groups regarding what type of information is most relevant, to on-the-ground intelligence, the provision of contextual analysis, the verification and forensic examination of documentary and digital information. And of course, we're aware that the different nature of mandates themselves and the resources that they're provided has implications on the type of contributions that they can realistically make. But we're hoping to come up with a set of recommendations that we hope will strengthen their role within this evolving ecosystem. And finally, we have a separate research project in which we're partnering with University, UC Berkeley's Human Rights Center and the International Bar Association, where we're looking at the questions raised by third-party control of digital information as it pertains specifically to social media companies. So we're looking at, once the decision to take down content is being made, what does that takedown look like? What does the preservation look like? And then what are the issues that arise with disclosure and what avenues are available, particularly when disclosure is to happen to international mandates. And we're approaching each one of these three questions separately because they raise slightly different issues, but also they, I guess, concern slightly different audiences. So I guess I'll just leave it at that for the moment, because I think I've spoken long enough, although I don't know how long I've spoken. But I guess this is just to say that we find this to be an extremely fascinating field, and I think that there's a lot that is going to be happening in the future. We see this as some of the key and biggest, actually, questions that the field of international justice is going to have to grapple with. And of course, we feel privileged to have an opportunity to work in this space, but I'm very much looking forward to the chance of discussing with all of you and hearing your thoughts on these matters. So thanks so much.